It is really a pleasure to be back. Last year was the first time I've been here, and it was a genuinely delightful evening, and we'll try to keep that going. When you hear these distinguished folks that I'm going to be talking to, you might wonder, well, all right, what are your credentials? Well, my father was a lawyer. My daughter, who is here, is a lawyer. And while I never took my law degree to take the bar, I do, every week, watch The Good Wife. What the heck? I have to say, you listen to this panel, and it's, let's see, a rabbi, a judge, and a lawyer walk into a country club. There's got to be a punchline there, but I don't know what it is. So, two observations about tonight, actually from other people. As we talk about the obligations and sometimes the dilemmas of lawyers, not in dealing with adversaries, but in dealing with the people who have hired them to represent them. One is from Charles Dickens, whose Bleak House is a novel that paints the law in a somewhat grim way. And he once said if there were no bad people, there would be no good lawyers, which may be some solace for those of you in the profession. The other, and some of you may know this, comes from Elihu Root, who was a very big shot macher back 100 years ago, although I doubt in his background anybody ever used that term. But he once said, about half the practice of a decent lawyer consists in telling would-be clients they are damn fools and should stop. What we're dealing with tonight is when that has not happened, when the clients have signed on with lawyers, and in this first segment proved to be very difficult. In real life experience, is it the case that you have had clients who have asked for things, have insisted on things, have demanded a certain approach that really gives you problems, and don't use their real names unless they're really famous?
Absolutely. I have had clients. My clients are in crisis. So sometimes it's not even what's on their list of demands, it's letting go that is the difficult part. It can be a lot like divorce work. When my clients are out of work, often they've been fired or they've been sexually harassed, but in the employment setting, my clients are hurting. And sometimes fighting over 20 days or 21 days or minutia is a method of exhibiting their hurt and their pain. And that's tough for me because I have to ethically be kind and understand they're in crisis, but still resolve the matter without, I'm going to see this lawyer again someday, and I need to resolve the matter and have my professional integrity in place. I find that being empathetic is a good tool.
But is there a time when what the client wants and what has hired you to do is in really serious conflict with what you think is the equitable solution to this? And in that case, I mean, I'm asking what you use to figure out which side of that you're going to fall.
Well, sometimes it's simple. I end up with this sentence after I hear, well, I really know things about this company. I know what they do with their taxes, and I have to simply say, well, you came to the wrong place because I'm just a lawyer, not an extortionist. So that's one way to send people on their way. Another is sometimes you just have to say, and this happened recently, sometimes it's easier not to be the spouse of somebody who's been hurt. Watching a loved one be hurt is awful, and sometimes I get the parents call me or a spouse will come in, and recently a spouse said to me, you know, I don't care what we get, I just want you to hurt them. I want you to hurt them. And I had to say, well, that's the mafia. That's not me. I'm also not in the mafia. All I can do is work within the bounds of the law. And that's a limited area to work, actually.
I want to come back to that, but Judge, I wonder when, in your years on the bench, I want to put this delicately, could you in effect sniff out a case where something was going on where you thought, one of the parties in this case is looking for something way beyond just a legal settlement? They're out for blood.
Yeah, those impressions form. I'm happy to say that I haven't really detected it much in the lawyers, but you can see it sometimes, particularly if the clients are in the courtroom. One thing you have to keep in mind is that as judges, our exposure to the clients is extremely limited. I had a little bit more exposure to clients during the course of conducting mediations, and perhaps we can get into that at some point. But there may be something going on in the background in terms of a client's desire for vengeance or a client's desire to exact pain, if you will, on the other side. But it's a little hard to tell whether that's what motivates a... They told me not to put this in front of my face, or else it would be a bad thing for the cameraman. Well, anyway, so sometimes you really don't know what that motivation is. The more difficult and more prevalent, although happily not too often, situation arises where a lawyer conducts essentially a case in a kind of a scorched earth policy, or relies on bombast or epithets or close to it, or impugns the character not just of an adversary's case, but of the adversary himself. So whether that represents what his client wants him to do, or whether that's just the way he does things, is hard to tell sometimes.
But under those circumstances, would you, your fellow judges, have the discretion to call the lawyers into chambers and say, look, I want this case tried on the merits, but this behavior's got to stop? Do you have the power as a judge to tell a lawyer the direction you're taking this case is unacceptable to me?
Well, normally in a pretrial conference, which I would conduct in a non-jury case, or part of a pretrial proceedings like a charge conference or the like before the jury joins us, I tell them the ground rules that I expect to be observed in my courtroom, and that is nothing less than the highest standards of professionalism, civility, and respect for the court, for your adversaries, for the witnesses and the jurors.
But if I may, that goes to behavior in the court. What about the fundamental strategy of a lawyer? If the lawyer is pursuing a scorched earth strategy, can you tell the lawyer, what's up?
Well, there are ways to handle that too. Mercifully, as a federal judge, most of that pretrial contact didn't come to me. The magistrate judges handled those skirmishes, which usually involve discovery. But I would have to confront them from time to time, and there are basically two ways to handle it. One, deny the applications for expanded discovery that are truly outrageous and oppressive. And two, along with that, or perhaps instead of that, just tell them that this sort of approach will not serve you well and will not serve your client well from a practical point of view. That often resonates.
Yeah, I could see how that would communicate itself quite well, actually, in the middle of a trial. Now, Rabbi Rapp, you're a rabbi and a judge. If he was a doctor, that's the trifecta. But in terms of what we can draw from Talmudic law, and there are a couple of areas here, but let's start with this. What guidance would a lawyer looking at Talmudic law draw in terms of, I want to be a vigorous advocate for my client, but there are things the client wants me to do that I'm uncomfortable with? Just tease that out for us.
Well, this might shock a lot of people in the room, but the Talmud does not allow for lawyers. And in fact, there's a major difference between a Beth Din setting and a regular legal setting, in that in American law at least, lawyers are charged not only with arguing facts, but they're also charged with arguing the law. In a Beth Din setting, upon the judge to do all the work on the law, and just a matter of the parties to present the facts. So as such, there really is no need for an attorney in a Beth Din setting. There are cases, if a person has trouble expressing themselves, they can bring a representative, but in fact, there's no real lawyers to talk of.
So in the absence of a lawyer, does that radically change the kinds of hypotheticals we're talking about? That is, there is no one who's been hired to relentlessly pursue one side or the other?
So practically nowadays, under constitutional law, everyone has a right to representation, even if you're dealing in alternative dispute resolution, and as such, people have a right to bring an attorney, and many people do bring an attorney. There are cases that are in the tens of millions of dollars. People are just nervous not to bring an attorney. In that case, we have all the same problems as the judge has. However, in a simple case when there is no attorney, and oftentimes this will be a matrimonial case, it'll be at least as acrimonious as with attorneys. And there definitely is, as the attorney pointed out, there's a lot of psychology involved. There's definitely a certain amount of time you have to allow the people to blow off the steam, whether it's a matrimonial case or it's an employment case, etc. And you'll find after a fair amount of time of saying what they had to say and listening to the other person say what they had to say, mediation might not be inappropriate at that point.
Here's something that I was wrestling with as I was thinking about this, Counselor Smith. If you were a criminal defense attorney, you not only are permitted, you are charged with mounting the most aggressive defense possible for your client, even if you know to a moral certainty that that client has committed a crime. And so in some sense, I'm wondering if we're straining at a gnat and swallowing a camel here. That is, a criminal defense lawyer would have no problem making a case that resulted in a murderer walking. But as somebody involved in a business dispute, you would have a great deal of difficulty fighting for what your client wants if you felt that client wanted something that was inappropriate or excessive.
Well, it's, criminal defense attorneys are much like my adversaries in my employment cases who represent the corporations that discriminate and wrongfully discharge people. They're forced to take positions that are not well grounded in the facts and the law. But it's easier to be a plaintiff's lawyer because I don't have institutional clients. My bottom line, it does not depend on promoting any one position which I don't agree with. I can simply, even under the ethics rules, say we're not going to get along. I'm not going to represent you.
Okay, it's an interesting characterization of your adversaries. Anybody here for, no, sorry, Judge, yes.
I think one thing that we ought to try to distinguish here is essentially three things. The position taken in a litigated matter, and particularly the position which a client wants you to take, even though you don't think it's the upside in the case. Two, the motive behind taking that position, which may either be virtuous or not so virtuous. And three, the manner in which an attorney presents that position, be it in pretrial motions, discovery, or at a trial before a jury or a judge alone. I personally never had too much of a problem. Now, of course, I didn't have a client since 1978, so I can speak with great authority. I personally don't have a problem with somebody advancing a position, even though it may appear to be weak, and even in a civil case. The party's entitled to representation, entitled to the best advocacy you can give them, and it may eventually help in terms of where the settlement lies. Of course, one has difficulties with the motive behind it. If it's for pure oppression and pure litigiousness, despite an obvious lack of merit to the client, once again, that's something a judge doesn't normally see, but I think that a lawyer really does have to filter out. But third, in terms of the manner in which a case is presented, you don't need to engage in ad hominem attacks or things like that. And in fact, if you do, it'll only weaken the position that you're espousing, whatever its strengths or weaknesses might be.
Rabbi, I want to come back to the point that you began with, because while in your courts there are no lawyers, in a broader sense, Jewish law and Jewish thinking ought to inform even those who are lawyers. So I want to come back to this point about what strikes a lot of people as a kind of fundamental conflict. One, I go and hire a lawyer to represent me. Advocate, that's the French word for a lawyer, right? I want that lawyer fighting for me. I don't want the lawyer telling me what I want. I want the lawyer within the limits of the law to fight for me. On the other hand, the Talmud may have much to say about compromise, about finding a reasonable middle ground. Is there some guidance that beyond the strictly legal, ethically, that the Talmud offers to a lawyer faced with that?
I think at the end of the day, we have to remember that a lawyer is a businessman like any other. And as such, just like if I was a doctor and a client came to me, and then my mother would have been more proud, as you pointed out earlier correctly, and hope she's not watching today. And also, if a contractor comes to get something fixed, there is a certain amount of ethics that a person has to have. As such, if you're sink is clogged, and with a little liquid Drano, I could clear it out. It's not ethical for me to say it's time that you got a new kitchen here because this is a big problem. So too, an attorney has to be very careful in doing what's really best for the client. The judge listed a number of issues that you get with attorneys. Another issue is, what we get sometimes, you get the feeling this case is going on forever because they're billing by the hour. This might have never happened, of course, in Europe, but I think it may have happened in mine. And as such, that's really a business ethics question like any other. What you really have to do is what's best for the client. If it's best to settle, so you should be settling. If it's best to push forward, if it's best to fold up, that's really what the attorney should be doing, despite the fact that for the attorney, him or herself, it might be financially beneficial to not go that way.
Could I just, the difference, I think, is when a doctor operates on a patient, if he cures the patient, nobody else gets hurt. Right. If a contractor fixes your sink, there's nobody else down the street, the sink is going to back up. But if Nancy Smith does her job the way the client wants, somebody may get really hurt. You want to take...
Well, that's why in my initial consultation with every client ever for 34 years, before I even offer to represent, I say, what do you want? The client who has the newspaper clipping of the $8 million verdict that somebody got in California, that's not going to be my client. Or we're going to have a really serious conversation about, that's not this case, that's not what I can do for you. Or I want revenge. And the answer to that is from a cold white season where Stephen Biko's, after the police under apartheid murdered Stephen Biko, his parents come to the lawyer and they say, what do you want? And they want justice. And the lawyer says, well, in most countries, justice and law are distant cousins. In South Africa, they're not even related.
In the time we have left, there are more specific kinds of difficult client issues that don't rise to high-minded intellectual levels, but can drive lawyers crazy. Now, I say you haven't had a client since 1978, so you are in great mental health.
Am I immune from this question, I hope?
But I'm wondering, that part of the stories are, for instance, the clients that decide to micromanage a case, the clients that call you every day, the clients, that read a newspaper story that their case was settled for, millions of dollars. Why aren't you doing this? And by the way, I've got 5 other legal questions I'd like to ask you about that I'm not on the clock for. What does a lawyer do in that situation?
Recommend therapy. I tell all my clients, I'm not a therapist. I can't help you feel better. It's not my job to make you feel better. You have to let me do my job as a lawyer. And most of my clients need therapy.
It sounds like this could be a room full of lobbyists for legal marijuana also, but that's a different issue. Judge, have you, as a trial judge, faced a situation where a lawyer has come into your court and say, I can't do this anymore. I got to I know we're in the middle, we've just done weeks and weeks of work, but this lawyer's driving me so nuts, I've got to get off this case. Can you do that?
I ran a fairly formal ship. Formal but friendly was the way I tried to describe it. It would be unusual for me, at least, to have that sort of an ex-parte or somewhat informal conversation with an attorney who is having difficulties with his client. We all know that there are mechanisms for an attorney to move to be recused from a case and be allowed to withdraw from the case, that's a better way to put it, based upon either problems that have been there from the start and couldn't be solved, or problems that have arisen in the course of the representation. I'm pleased to say I didn't have to deal with an awful lot of those, but when you do, you just evaluate the situation. There are a lot of factors you have to take into account. Is this a ploy on the eve of trial to somehow or other secure an adjournment, which otherwise might not be granted directly? Or does it represent a true conflict, more in a lay sense, if you will, as well as a legal sense, between the lawyer and his client, so that the lawyer can't function effectively and the client can't be adequately represented? And we have precedents and we have rules, of course, that allow us to deal with those, and I have had to deal with them. Usually you don't involve the other lawyer and the other party, at least in the details. A lot of those applications are filed under seal because they represent attorney-client communications that are being used as a source for the application. On the other hand, I would allow other counsel, particularly if I thought they were prejudiced by a delay resulting from this and a new counsel coming into the picture, to at least be heard on that issue. It's thorny, it's difficult, it's unfortunate, but there are occasions when it's really the only solution.
Go ahead. Ms. Smith. Go ahead.
There are occasions when we have had to make a motion to withdraw if a client had a completely ridiculous view of the case and did want us to prosecute it in a way that was inappropriate. But also, sometimes we have used the threat of a motion to withdraw. For instance, we had a client who claimed that she was the victim of this terrible sexual harassment by the owner of a very, very, very lucrative company. And it turned out when we got her easy pass that she had been lying to us about what looked like an attempted rape. And once we found out that she had been lying to us, we brought her in and said, okay, you're going to drop this case, and hopefully we can get them not to sue you for fees. And she was very angry and kept up the pretense. We had in black and white, and we had to say, all right, we'll do a motion to withdraw. And she agreed. So the motion to withdraw was out there as saying to the client, you're going to, explain yourself. Explain yourself.
But in a way, that's a fairly easy call, right?
Of that blatant a lie?
Yeah, as opposed to the more subtle things. Now, in the vineyards where you labor, again, we're not talking about a lawyer. To what extent is it permissible, is it appropriate to hear out the parties and find that one party is, just as a matter of personality and temperament, really, really difficult to deal with? Does that in any way affect the judgment of who's right and who's wrong?
It shouldn't, but obviously it does. I mean, we're all human at the end of the day. I've sat on cases where clearly one of the sides was a raving lunatic. I remember one of my favorite cases dealt with a slaughterhouse in the Midwest, where there was a fellow who was involved in the ritual slaughter who had been let go, and he was suing for wrongful termination. And the case involved, so first the manager came, he says, you have to understand, we have an assembly line, and there are 20 people on the line, and if this guy shows up 10 minutes late, it stops everything. There's tremendous monetary loss, and this guy is habitually late. And the guy got up and he said, that's totally not true. The fact that I'm late has nothing to do with why I'm being fired. He said, so why are you being fired? Because I eat kasha. So he said to the guy, why would they fire you for eating kasha? He said, that's a good question. You go ask them. I agree, there's nothing wrong with it. So obviously, you get a feeling from the get-go that that the elevator might not be going to the top floor here. But at the same time, you do have to give him, he has to speak his side, etc. Even though, really, yeah, it does play somewhat of a role in how you're going to view this case going forward.
I don't think we're seeing this on The Good Wife next week. That's just a wild case.
Okay.
All right, we've only got a few minutes left, I think, on this panel. So let's see if we can you actually already have done admirable service in providing not just the cause, but a remedy. So if you were meeting, I'm going to ask each of you this, even though, one of you is not a lawyer. If you were convening a group of lawyers or just having a social evening and they were complaining about these issues, and we just don't know, we get too many clients who drive us crazy, who just aren't worth it, whatever. What's the single best piece of advice you could give those lawyers to say, here's an approach to such clients that might save you a lot of heartache?
Wow. Well, I'm going to draw on my experience from ice hockey a little bit. As you know, even at the amateur level, that's a relatively violent and very fast-paced game. Time and time again, as a matter of course, the referees will talk to the captains before the game, either at the high school or college level, and basically tell them, listen, taking control of your team and taking control of your players is up to you. You're the ones that are on the ice. The coach can't do that from the bench. Furthermore, this is a tough game for you. Conference game, playoff spot on the line, whatever it might be. But don't fail to exercise the appropriate amount of respect for the team that you're playing and good sportsmanship in the course of the contest, both during it and afterwards. I think there's a lesson that we can all learn from that. Most of us, happily, I suspect, were involved in athletics at some level. And if your coaches are any good and your parents are any good, they taught you that those values were important as well. So I would suggest to the lawyers who have to deal with a really difficult client, whether somebody's out for blood, whether somebody's terribly emotional, whether somebody is saying, that jerk hasn't got a leg to stand on, et cetera, maybe you try to talk to them a little bit about core values in terms of mutual respect, at least for a person, if not for a position, and remembering where you danced as a kid, perhaps, if good sportsmanship had an important value.
Well, it seems to me if we want lessons of good sportsmanship, we should turn to the National Football League.
Yeah.
I did not deal in pro sports. Thank you.
Nancy Smith, before, I want you to answer that, but tack on to it's a question that the rabbi has raised, which is, and I realize this may not come up in your particular line of work, but what happens in a situation where a client walks into a lawyer's office and has a piece of evidence, a gun, an illegal substance, and just says, I want you to hold on to this. What's the ethical obligation there? And then you can give us the advice. I'm not sure this happens in employment discrimination, but...
That reminds me of the lawyer in Breaking Bad. I think he had a safe full of illegally gotten gains. It is not something I come across in my practice, although there is a new push to try to undermine discrimination and whistleblowing cases by attacking the client who brings evidence to the lawyer of the whistleblowing or the discrimination. And our court has carved out a safe haven where if you didn't steal the documents and if you were entitled to have them and they're not attorney-client privilege. So if somebody brings something to me, before I look at anything, I go through the factors. Where did you get that? Oh, you drafted it yourself. Great. Is that the original? No. Do you have a right to have that? You didn't get it off anybody else's computer. You didn't go in anybody else's desk. It's not attorney-client privilege. So before I look at anything, I go through those criteria. But to answer your second question, which was your first question to the judge, I agree with the judge. I get very philosophical with my clients and talk about things like the best revenge is to live well, and living in a place of negativity and hurt, and it just is not a healthy place. And often I say, this person hurt you, this employer hurt you, but don't give them the power to ruin your life. Let's move on. It's healthier to move on. And leading with kindness and empathy, and sometimes bringing in the family to help the person think of the future and move forward.
So it sounds like it's as much being a therapist as a
I try
lawyer.
really hard not to be a therapist. I'm so unqualified, it's crazy.
So, Rabbi, when I was in law school, there was a famous professor at Yale who used to, every few weeks, turn to us and say, growl, and say, just remember, you're hired guns. That's what you are. You're hired guns. Now, if a lawyer came to you and said, again, looking for advice, not legal advice, and said, I've got this real problem, but I remember what my law school teacher told me. This guy hired me. I'm a hired gun. What advice can you give me to resolve that kind of dilemma? How should I think about this?
Well, obviously, you're not a hired gun to violate the law. If there's an ethics violation, the fact that the person's paying you to do it doesn't make it any better. Let's point out we're not the mafia here. Just because you paid it didn't make it okay. I think part of it is, I think the question was asked regarding a criminal client, where you legally have to represent this client, even if you know the client is a murderer or what have you not. And to a certain extent, it comes down to grin and bear it at that point, because this is what you have to do. One of my favorite stories, actually, I don't have a source for this, but it's
Hey,
related.
I'm a journalist, I don't care.
It goes, actually, it's a little bit related to the Jets as well. When J. Seward Johnson passed away, there was a major fight over his estate. I don't know if people remember this back. Remember that? There was this chambermaid who got $500 million, and for some reason the children didn't take it well. So they decided to litigate, and she hired Sullivan Cromwell, and they fought the good battle, and she walked away with over $300 million under settlement, which was a lot more than anyone expected her to get. The story has it that the attorney, after completing the case, went to upstate New York, purchased a cow, named it after the client, and shot it.
You know, I think tonight, whatever happens, we may have heard the single most practical piece of advice that we're going to get.